what you're saying.
Now, Manas, kindly go. Yes, therefore take it slowly, Manas. I'm dealing with that. Petitioners submit that 21A does not create a barrier to a constitution compliant reading. 21A only applies for marriages of two Hindus. Further, even when two Hindus marry under SMA, 21A links the SMA regime to personal law for only two narrow aspects. The whole case should go out of SMA because of this argument, according to respondents. Succession and membership of HUF. Succession and HUF, that's all. So 21A is A, limited to succession and HUF, second limited to two Hindus. Now, Manas, kindly come to my answers. I am, Manas, respectfully submitting three possible interpretive answers. And your Lordship, I am neutral to all. I have a personal choice. It doesn't matter. There are people here, other people. All three, according to me, it's a scare argument to say that so much big is happening, whereas these three, any one of them, your Lordship's choice answers it. Firstly, theoretically, this Honorable Court may elect not to pronounce on the applicability of 21A to non-heterosexual Hindu couples in the present litigation and leave questions of succession open for future litigation expressly. That's only option 1. See option 2. Secondly, in the alternative, the Honorable Court may hold that the SMA will apply to non-heterosexual couples exactly as applies to heterosexual couples. Today, your Lordship has it applying to heterosexual couples. By virtue of the introduction of 21A, specifically, Hindu non-heterosexual couples will be governed by the HSA, just like Hindu heterosexual couples. But all non-Hindu, Christian, Muslim, will be governed by ISA. This is number 2.
But to achieve this reading, now read what follows.
Yes.
What do we have?
I have to. Is your Lordship's shy of doing this minimalist interpretation? Will be the question. That's a valid judgment of your Lordships. If I am asking for something which your Lordship has never done before or is unknown to your Lordship, is right. I submit this is a minimalist. See the next. Yes, next para. This is minimalist, is my submission. To achieve this reading, the Honorable Court may extend its gender-neutral reading of the SMA to the HSA and the ISA. That's all the Lordships do. Whatever it has to hold: 1, widow and widower in the ISA, and male Hindu and female Hindu and widow and widower in the HSA shall be interpreted in a manner that is agnostic of gender and sexual orientation. That too, Malas, there are two options. By specifically saying personal law is out.
Really have to then recast or redraft the provisions of the Hindu Succession Act also.
No, your Lordship, it doesn't have to recast it. Your Lordship has to say, no, my Lord is only in SMA. My Lord is not going to HSA. My Lord is saying either of two things.
Saying that to achieve this reading,
yes,
this Honorable Court may extend its gender-neutral reading of the SMA to the HSA and ISA. It may hold that the words widow, widower in the Indian Succession Act, limited to issues of marriage, and male Hindu, female Hindu, widow and widower in the Hindu Succession Act, again limited to issues of marriage, shall be interpreted in a manner that is agnostic of gender and
Correct. Now, what does it mean? Give me a minute. It's very important. It means that your Lordships will first put a caveat at the beginning: we are not getting into personal laws. Second, cumulatively, your Lordship would say that today all heterosexual couples are governed with 21A in only ISA, except for Hindu couples. So the large majority of non-Hindu couples are covered by ISA. Third.
The largest number of people.
No, that's the third. So I'm not avoiding it. I understand. My Lord is right. Third, for the Hindu couples, the agnostic reading will be to words like male, female, widow, widower.
In other words, we are creating a new regime, essentially. There.
That may not be a new regime. That is even in,
No, it's not. If you drill down a little bit, the complication.
Yes.
Now, two spouses of the same sex, one dies. Now, who will that be? What is the kind of estate that she?
If your Lordship adopts, Malas, may I read?
Well, then you see, when it comes to male, of course it will be a son. He will be treated as a son. When it is a female, he will be treated as a daughter. Question is, what is that spouse? Will he be treated? Will that spouse be treated as husband?
When a male Hindu dies intestate, But the first priority is to the widow.
Yeah.
If it's a same-sex male couple
Yeah.
and the male has died interstate, there'd be no widow.
No, but there will be,
So what you are now therefore
Your
saying
lordship
is that read widow.
reading that to be a compliant. It's the widow,
Substitute
the
another
surviving
word for
spouse
word
of widow.
widow.
Willy-nilly, we do enter into personal law.
Or,
See, this formulation has one,
surviving spouse.
No,
That's true.
see,
That's true.
it's a bit oversimplistic. Hindus, you say only Hindus, no problem. But at the same time, there is no problem when it comes to Indian Succession Act, where the Christians, it anyway applies to them.
No, I have no problem with
Then we
ISA.
come to the Muslims. Are the
21
one
is
who-
creating a problem.
Muslims are the one who are now bound by the ISA.
Yes. No, may I just,
Others,
no, may I just say, there's a third option I'm given. The problem is arising because of 21A, which takes you back. It is not arising for any other category. So Muslims and Christians who go under heterosexual couples under SMA go under ISA.
But Dr. Singh,
Now, the third one is,
look at how that third, you are yourself struggling at an intellectual level. You say it is submitted that there is a third option.
Yes.
That this honorable court may hold that since religious and personal law related issues by agreement of parties are beyond the scope of
that's what I
litigation.
started the matter with, Malas. We are saying
We
outside.
we can't rule on.
No,
a
but we
constituted
started the
issue
matter
by
by
saying
saying-
that look, by agreement of parties, this
No,
has been
forget
kept away
agreement,
and create
Malas.
a minefield for a future bench.
Malas, forget the agreement. Your lordships is saying that from the inception, the petitioners, Malas, the petitioner, no, kindly read the whole.
You have to then decide it's.
No, Malas, kindly allow me. No. Malas, kindly read the whole para. This matter started by the petitioners who invoked your lordship's court to say we don't want to get into personal laws. Your lordship can certainly rely on that petition. But now read the whole para. Just allow me. Third para. It is simply the third option. This honorable court may hold that since religious and personal law related issues, forget agreement of parties, I need to delete that word. I mean, I don't want to, not necessarily, are beyond the scope of this litigation, which your lordship declared at the beginning when the matter started. It follows that personal law statutes, as well as provisions of secular laws that relate back to personal laws, that is only 21A, are excluded from consideration. Since 21A itself was introduced as an exception to the regime under 19 to 21, non-consideration of the issue would simply mean a reversion to the default regime of ISA.
So are we reading up or are we reading down by doing that?
Well, it's,
Which of the two would it fall under?
well, I am saying there are two options. Either it will all fall under ISA or your lordship may apply the
so then we have
spouse
to-
and person
we-
interpretation for HSA
So
Hindus.
then we come back to the old position that
Yes.
when it comes to same-sex couples, we will interpret it in a particular manner. When it comes to heterosexual couples, we will read all those laws in a different manner.
Well,
We will have to have those
In
two
option
different
two-
interpretive tools.
well, so can I just summarize? What is it? After a preliminary statement that when the matter started, your lordship had made it clear, and the petitioners have also said that there is no going into personal law, your lordship may adopt either of two. Allow me to summarize. One, that everybody is under ISA and 21A will not apply to the same. Alternatively, that everyone is under ISA because ISA is not posing a problem. But for same-sex Hindu couples, your lordship reads the word spouse or a word person. That's the summary of the whole thing. That much your lordship will have to do. If it is beyond the bounds of judicial writing, it is beyond the
Why
bounds.
should we include Hindu?
Please see the logic in my para 15. But I am saying this cannot be the complete exclusion which the
Then
respondents would want.
then there is a classification amongst the same-sex couples. You are saying that those who fall in 21A, you treat them differently, leave it at that. For the others, you have ISA.
No,
You are actually subclassifying now.
no, not in the second option, in the third option, yes. In the second option, the better option is whether your lordship interprets it to mean spouse or person. Then there is no
So
such problem.
Hindu non-heterosexual couples
Yeah.
would be governed exclusively by the ISA according to you.
How is that possible?
On option 3, not on option 2. This is important. Let us forget option 3.
Then
Option-
neither are we reading down, nor are we reading up, nor are we striking down 21A.
No, so let me leave aside option 3. Let us say that your lordship keeps 21A.
Dr. Singhvi, we are not writing a blog, we are writing a judgment for society.
Well, your lordship is keeping 21A. Let me tell your lordship how
Right.
I would respectfully submit a judgment can be written with 21A existing. It will certainly not be a block, Balas.
See, you may have that legislator's pen elsewhere. But you can't persuade us to use this here.
I can only make a submission. Balas, let us just for a minute focus on 21A.
Yes.
Your lordships may adopt the second option. 21A is given full force if your lordship reads the word spouse and person. That's one sentence answer. Forget the third option. 21A is excluded, as my Lord Justice Bhatt said, only in the third option. In second option, since 21A is there, your lordship applies it, but your lordship would have to do person or spouse that much of reading. That's the long and short of it. Now, is it such an insuperable thing that the whole case, Malas, should be a mere declaration of marriage? Then, Malas, there is virtually an empty shell. Malas, I would say it is only, Malas, a cardiac checkup.
Or is it a transplant?
That too, cardiac checkup, Malas, that too by a physician, not a surgeon.
Ultimately,
Physician.
court, please have heart. That's what it is saying.
That's neatly put.
Well, let's just see the conclusion at para 15.
Yes.
Just see the conclusion at para 15. Because then I have these special categories coming after that. It would not follow from this approach. Now, I am giving the answer to a possible objection to my approach. It would not follow from this approach that non-heterosexual Hindu couples who marry under SMA would be excluded from legal succession regimes altogether. Today,
We'll resume tomorrow. I think it should be around
12-ish.
12-ish, but we'll resume the moment we are ready.
Yes, I'll take very little time. Very little time.
And now for all of you on this side, 1 hour flat. So please in the
Can I make
invitation
only
out
one
time.
suggestion, but I only want to make a suggestion.
Yes.
I don't want to argue, Milord.
Yes, yes, Mr. Rodgi.
Milord, my suggestion is this. If you agree, Milord, to some part of SMA, then, Milord, it is there.
Then, sorry, if
If
you
you
agree,
don't agree to SMA, I am making that suggestion as an alternate. His suggestion is this. That, Milord, your Lordship grant us a declaration that we have a right to marry. Now, Milord, we require in reality some state recognition, a document that yes, you have got married. I go to a bank, I go to an insurance company, I want an insurance for a family. I need to have a document. I can't go with the judgment of the Supreme Court and say I have a right to marry and I am married. The bank manager or the insurance will say, show us some proof. Therefore, I am submitting that, Milord, a document of marriage by way of an affidavit between two parties that I take you as a spouse in marriage can be, Milord, a via media for registration under Section 18 of the Registration Act, which is registration of an optional document. So, not SMA. So, I steer clear of SMA. I have, Milord, two affidavits. I take you as my spouse. You take me as my spouse. The affidavit, Milord, form I have taken from the Act. With that affidavit, I can go and have a registration. So, if I go to a bank, I can show, Milord, I have some registration. How else will it happen? Milord, Section 8. Milord, I need some document.
we'll come back.
So just keep, Milord, Section 18 in view. 18F is an optional document.
This is obviously wholly without prejudice.
Yes,
We are
I'm
asking
saying-
something totally
I'm
else.
saying steering clear of.
Wholly without
Arey
prejudice.
bhai, I am saying so. I am at the last, I'm the bottom rung.
After he says.
We can't get everything, we have to take what we get.
Yes.
Lord, may I just take two?
Tomorrow.
Tomorrow, tomorrow,
Your Lordship, my Lord, can I just take 2 minutes?
tomorrow, Mr.
Lord, can I
It's already 4.
Tired souls are not receptive souls.
And the heart would still be in the right place.
permit.
Online you want? Sure, certainly, no difficulty about it. Yes, come online, no difficulty.
So,
Then inform you online.
round, 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 round.